Hi, and welcome to PlanStrongerTV. I'm your host, David Holland. On today's program, we're going to talk about trusts and why they're so important. My guest will be attorney Matthew Shapiro. Stick around. Welcome, ladies and gentlemen. So, trusts. Do you need one? It's a great question. People struggle with this because they're just not sure if their situation warrants a trust, if they want to pay for a trust. It just seems complicated. It seems inaccessible. Well, I can tell you that that decision, of course, first comes with a consultation with an attorney, okay? You need to talk to an attorney. It's not necessarily information you might hear out there on the internet or wherever you may get your financial information. Now, the other thing to know about a trust is whether it's right for you and how you set it up depends a lot on your individual situation. The real question, and this is how I frame it with people I meet with, is who do you want to get what when you die? What do you want them to get? Who do you want to get the stuff? And when? Because some people can feel comfortable leaving their money to their children outright. No problem. I've got 3 kids. I just want all my money put in one big stack, cut into 3 pieces, and given to my children. For some people, though, that's not really a practical or effective way of transferring their assets to the next generation. You may have a second marriage. You may have children from a previous marriage. You may have other complexities. You may have a child that you just don't feel comfortable getting a large chunk of money all at once. It's okay. With planning, you can make it work. You know, it doesn't have to be overly complicated or stressful. You just have to sit down, talk about what you're wanting to accomplish, make sure that you explain your situation fully, and let the professionals guide you. You don't have to do it just on your own. These are the kinds of things we're going to talk about in more detail with our guests on the program. So stick around. We'll continue in just a moment. I'd like to welcome back Matthew Shapiro to the program, a local attorney in the Florida Daytona Beach area. And Matthew is a specialist in estate planning and real estate law. So welcome back to the program, Matthew. Good to have you again.
Thank you, David. I'm happy to be back.
All
Appreciate
right.
the opportunity.
Well, you're very welcome. And you know, you and I had some unfinished business last time. We talked about estate planning. And we didn't get a chance to dig into what you know, of course, is a very important area for people in their estate plan where their situation warrants. And that is the whole subject of trust. So, you know, we can move past maybe some of the basics now and talk a little bit about some of the advantages and disadvantages. You know, there's so many questions people have. Do they need one? Are they private? Do the beneficiaries need to know they're even beneficiaries of the trust? Who's involved with the trust? Do you need a trustee? Can you write your own document? So we've only, you know, it's only a half-hour show. So, so you share with us as much as you can in your practice and doing this work for clients, you know, some of the answers to those questions so our viewers can understand how this works.
Absolutely, and I appreciate you having me on, and I think it's a great topic. And if we talk about estate planning 101, like a college intro class,
Right.
You have your wills, and you have your basic healthcare surrogates. And the trust is kind of like level 2. It's a little bit more advanced planning technique that really gives people the flexibility to enact plans that meet their needs. And I guess the basic idea, to boil it down to the very top of, I'll say the iceberg,
Right.
With trust would be the idea that you are essentially giving your property to someone during your lifetime, and that's a trustee. And that person is oftentimes you. During your lifetime, you control and do with this property as you want. But upon your passing, another person, your successor trustee, is going to take it over and follow your wishes. And with other types of planning, David, what you're really doing is just going from point A to point B.
Okay.
Let's pick an even number. I have $100,000. I'm giving $100,000 to my daughter, and it's hers to do with as she pleases. Whereas with a trust, you're getting to give instructions over how that money is going to be distributed, when it's going to be distributed, what it can be used for. And, you know, I'd tell people, I'd caution them, a lot of people think, well, I don't know if I want that. I don't want to be ruling from the grave. This idea of if she marries someone I don't like, then the money's going to go somewhere else. That's not what a trust is about. A trust is really about knowing what the needs are of the people you may be leaving it to and making sure that you're putting them in the best position they can be in moving forward.
That's very good. Well, so there's a lot there to unpack. So the first thing is you really, and you know, for a lot of people, they go, you know what, Matthew, that doesn't sound so bad to control from the grave. I know my kids. I don't want them to get, in fact, most people I talk to in the financial planning work I do, every week I have somebody say, you know what, I don't really want them to get all this money at once. I want it to be held. I love the idea of it being dispersed over time. I don't want it to mess up their life. People are concerned about divorce with the rate of divorce in our country. They're also concerned about creditors getting to the money. So there's a lot of things that the trust that it can do to help with those situations. So that's not a bad thing at all to be able to set these things in motion and have a little bit of control from the grave. It's not like you're trying to control people's lives, but you are helping them with these resources and setting boundaries.
And that's a perfect way of putting the point I was trying to make with it, is that don't view that as a bad thing.
Yeah,
it's not a bad thing to want to have control over the assets even if you're not there, because oftentimes you know your family best. You know your heirs better than anyone else, and you don't want to create a bad situation for them.
That's good. Well, we've all seen the television programs where, you know, there's this some sort of murder mystery or some plot, and there's the reading of the will, and there's, you know, all this stuff. One of the things that people ask me is, well, does the person even need to know that they're named as a beneficiary? Because I don't want them necessarily to know that those assets are out there. How much privacy, I guess, do you get? Because I know with probate, it's more of an open process. Talk about some of the privacy you get by doing a trust.
Sure, great question. There's actually two prongs to that. So the first idea we talked about in a previous show, you know, wills and probate. When you go through probate and you have a will, it's recorded in the public records upon your passing. So if you want to leave money to someone other than spouse or children, or you want to leave it to a charity and you don't want people knowing what you're doing, they're going to know what you're doing if they care to, with a will.
With a will, okay.
With a trust, though, what you can do, there's nothing to record, there's nothing in the public records that will actually disclose the terms. So if you want, we have clients all the time where they say, I don't want neighbors, or especially people who belong to a very tight-knit sub-area of the community, they don't want others knowing what they had or where it's going, and a trust will protect that. So just on a global level, there's much more privacy. Now, as far as with the actual beneficiaries, at the time you make the trust, you don't need to tell anyone that they're a named beneficiary in that instrument, because there are always exceptions. We may get into them today. For the most part, trusts can be revised and revoked over time, so they don't have what's called a secured or a vested interest until you actually pass away. So if I wanted to leave money to a child and I didn't want them saying, well, the gravy train's here, I don't need to work anymore, I don't need to tell them that. But when the trust is finalized and becomes irrevocable, at that point in time, the trustee does have a duty to notify anyone that has rights under it and to say, you've been named, if you want a copy of the trust, you can have a copy, here's how much money's in there. And that's for everyone's protection, that beneficiaries should know that they're entitled to a certain amount of assets to make sure that the trustee's doing their job.
That's excellent. Okay, so they don't need to know initially, because as you said, Matthew, you may decide to change your mind down the road. You know, so you set up this trust and you say, okay, this is what I want, and then down the road, situation changes, needs change. I was just meeting with a client where some of their beneficiaries have passed before they did, so they're updating their beneficiary designations on the trust. So you have the ability to change it, but then once you die, or if you become incapacitated, which also might prevent the changing of the trust, then it's set in motion. So when people are notified, if somebody's notified that they're a beneficiary of the trust, they have rights to get this information you shared, and then going forward after that, the trustee of the trust disperses this money out. And this can go on for many years, right?
Oh, absolutely. It could, technically there are trusts that can last for hundreds of years. Now, that's not what I'd necessarily recommend. But no, there's no set time limit, in that it could be something where it's a trust for grandchildren, great-grandchildren, or it could be just simply immediate heirs, like children or close friends and family. You know, you really, subject to a couple laws out there for public policy, are only limited by your own creativity. So I think, you brought up the point of should beneficiaries know who they are ahead of time because we want them to still maybe not rely on the trust. You can put clauses in there that say if someone goes and wants to pursue a certain degree or they go out and get a certain job, they can get money to support that endeavor, or they'll get more money the harder they work. Or if you're worried about someone who's not going to get off the couch and wants to become what they call affectionately, the trust fund baby, you can put less money in there and say, if you're not going to work hard, then I'm not going to let this support your lifestyle. You're limited by your own creativity and your own situations only. You can really do just about whatever you want with those terms.
It's very good. Well, as I mentioned before, a lot of people are concerned about a big lump sum chunks, but you can have that trust provide for multiple people. You could have a dozen different beneficiaries, each one getting distributions at different times. It can be multi-generational, as you mentioned, where I've got a family I'm working with right now where they are providing for son and daughter and their kids, and everybody is able to benefit from this. But again, they reserve the right to change this if they need to during their lifetime.
Yeah.
Yeah.
And it's in every scenario is different, obviously. And in most cases, though, with our clients, what we generally put in when you're dealing with beneficiaries, and it's not going to be a lump sum payout right away, which most of the time it's not, we usually put something in there that takes care of standard health, safety, maintenance, and education.
Okay.
That's kind of layer one. Is what we'll do is we'll say, okay, we're going to designate a certain amount of funds for the son, and if he runs into any issues, not of his own doing, where he has a health emergency, or he needs additional support, maybe he's going through a hardship, or he wants to go back to school and get an MBA, the trustee can use money for them, additional funds. So we'll always put that as a first layer, and then from there you could say, I'm going to give them yearly distributions, I'm going to give them monthly, I'm going to do a third at one age, a third at another, and then wrap it up when they hit 55. It can be tailor-made to any situation that may arise, all the way from very little control to a lot of control.
Okay, that makes sense. So the person setting up, they're called the grantor of the trust.
It would be grantor or settler.
Okay.
In law, we have a lot of these fun little analogies or synonyms where we use them interchangeably. So people may hear it one way versus another. But yes, you have someone that's going to set up the trust and fund it.
Okay, so there's a settler or the grantor. That's the person setting up the trust. So they set it up, and then you mentioned they can be their own initial trustee, but there's going to need to be a successor trustee. So this is somebody that is going to, in effect, take full responsibility for what's in this trust and discharging these responsibilities of dispersing money out, hiring somebody to manage the money, an investment professional, or they themselves might be an investment professional. So that's a lot of responsibility. In other words, this is the person that you are trusting to oversee your trust. So it's obviously very important. How do people make that choice?
It really depends on the family dynamics and the people they know at the time they're going to decide it. So I think you've really hit upon two issues. First is you can be the trustee of the trust yourself while you're living. That's no problem. You can't be the trustee and the only beneficiary.
Okay.
So you can't do it. As long as there's someone who's going to be a beneficiary, it can be you and someone else, but there always has to be one beneficiary that's not you if you're also going to be the trustee. So assuming that the legal portion is good to go, really what I tell people is, what are your goals? What are you trying to accomplish here? If the trust is simply, I just want privacy and everything's going to be distributed immediately and it's a relatively, I'll say, small estate for tax purposes, so it's not going to be incredibly complicated, then maybe, a brother or a close friend is good if you trust them to carry out the wishes. The last thing you want is litigation arising and the money that would have gone to the people you intended it to go to going to attorneys. And while I like making a living, that's not what the client, that's not what the client desires or wants. If you have a more complex plan and you don't have someone that you think either you trust, or you don't feel that they have the knowledge or experience, or that maybe even, David, it would be a burden on them to oversee these things, then absolutely you can step in and have a non-family member or a professional serve in that role.
Well, because you have some potential conflict. I mean, in many families, there are rivalries between spouses. I know that never happens, right? Yeah, there's rivalries that exist. And, when you talk about this money moving from one generation to the next, it's very likely at death where there's already a lot of emotional.
It's a traumatic event.
It's a traumatic event. And any childhood grudges or, you always got an extra scoop of ice cream more than I did, all that stuff comes out. And so sometimes it really helps a family for them to have somebody third party to have them oversee the trust. Now, once all this plays out, then this money is dispersed, that you keep track of all of it, and then at some point it eventually is all dispersed and then the trust stops.
Yes, correct.
Okay. Now, during this whole process, again, one of the things that sometimes people overlook is the importance of this trust also operating during the lifetime of the person who set it up. So if somebody sets up a trust and then later they become incapacitated, they perhaps start to develop Alzheimer's, or they have a health situation where, you know, it triggers that they can't take care of things, the trustee can step in and start managing the trust at that point?
It's not that someone needs to pass away, it's just that they become incapacitated, which is a fairly broad word. There can be temporary incapacity, there can be permanent incapacity, and then there can be obviously death, in which case then certainly someone can't serve. But yeah, some people will set trusts up during their lifetime with that need in mind, that they may need funds and they may need someone to oversee it. And not to go too far into it, you know, for today's purpose, but there are also trusts out there, special needs trusts and Medicaid trusts.
Right.
So you may have a child where something happens to you, those funds need to be held in a certain manner, and you also want to make sure it's not disqualifying someone for aid that they're receiving. So there are many different types that can come up where planning during the lifetime and potential use of that trust during the lifetime may arise.
That's well put, Matthew. The other thing is not just for kids and some of their special needs, but also, you know, we have more and more the marriage, divorce, blended families, all of these things. So with that, I would imagine that you see a lot of times the trust being used to kind of segregate and maybe keep, you know, the finances somewhat organized.
Well, I think there are two scenarios that pop up when you talk about unfortunate, you know, issues in modern living and that divorces happen more than we'd probably necessarily want them to. And the first would be after a divorce, there can be a second spouse.
Right.
You may have children from a prior marriage. So the issue you have here is, okay, let's assume you love your second spouse, you care for them. That may be a 25, 30-year marriage on its own. And you want to make sure that when you pass away, that spouse is cared for, but you also want to make sure that your 3 children from the previous marriage you equally love and care for receive something.
Okay.
So with a will, again, it's point A to point B.
Right,
you either choose, I'm giving it, you know, a third to all of them, or I'm giving it to my spouse, or I'm giving it to the children. There's no control once it goes anywhere. You can set up a trust to say, okay, the assets that are just mine, that I acquired prior to the second marriage, you can use those, trustee, for my spouse's benefit. You can oversee the home. You can make sure she has a place to live or he has a place to live. And that upon her passing or his passing, whatever's left in that trust that's been overseen can then go to my children. And there's some other laws that will interplay with how much you can do and in what manner. But the basic idea would be of making sure a spouse is provided for and that there's still money left over for the children. The second issue, though, is not necessarily your marriage, but what about your children or your beneficiaries' marriage? If you know that your child's in a relationship where maybe it's not a good one right now and there's a strong chance it could end in divorce, you don't necessarily want all the inheritance going over there, and then if a divorce happens, it's going into what I'll call, you know, the equation of marital property and what's going to go where.
Right.
So you could say to them, okay, we're going to give it over a certain amount of time and certain distributions, and you can put a creditor clause in there that would also apply in a divorce proceeding. In Florida law, this has actually come up several times where usually unless it is a support obligation, like child support, and unless it's a mandatory distribution, that money can be protected for the most part in those types of situations.
That makes sense. That matters to a lot of people, that they are concerned about maybe something happening. And with the divorce rates, it's just a reality that this can happen. So I would encourage our viewers to really think about these things and how they can be put together and really personalized to their individual situation. I'm really glad you could come back and spend some time with us, Matthew, and it's always good to be with you.
David, as always, I appreciate it, and if there's anyone out there that's considering having this done, I'd really encourage them to meet with an attorney, talk it over. As I said, you're only limited by your own creativity, so there's a plan out there that'll fit everyone.
Very good, very good. And more information over at PlanStrongerTV.com about Matthew and what he does and his work in this area. Thank you, Matthew.
Thank you, David.
All right, it's time for viewer questions. And these first set of questions comes from financial seminars I do, and people ask the same question over again, so I want to share it with you. Are trusts just for the wealthy? Are they expensive to set up? Two great questions. Here you go. First, they are not just for the wealthy. Now, if you've got millions and millions of dollars, then yes, you probably need to consider a trust. But for people with hundreds of thousands, they too may need a trust. It really depends on the complexity of your situation and what you're trying to accomplish. I'll give you a very simple example. Let's say a woman is a widow. She's got 3 children. She's got some investments, some cash that total about $100,000, and she's got her home, which is worth maybe $200,000. So her total estate is about $300,000. Well, she has concerns about leaving all of that money outright to her 3 children. It's going to be split 3 ways, but she's concerned about leaving it outright. Now, in addition to that, the 3 children are all in different parts of the country. They don't reside close to her. And she wants to make sure that everything is easy and not a big fuss. Everything can be taken care of. Well, she might be a good candidate for a trust. Here's how it would play out. She passes. The cash, the investments, all of that can go into the trust. Her successor trustee, the person she's designated to handle her estate and who is overseeing this trust, hires the realtor to sell the house. The money comes into the trust. So she's got now in the trust for her beneficiaries this $300,000. Everything is accounted for, taxes, bills, all that stuff is done. And that final $300,000 then can be dispersed to the 3 children, again, in different parts of the country. Now, if she has a concern about leaving that money outright to the children, she can have the money held back in the trust. She may feel comfortable, for example, with 2 of them getting their money outright, but let's say she's concerned about one of them getting the money and just blowing it all at once or doing something that may be self-destructive. She can have her successor trustee hold on to that money, manage it, and disperse it over time, say $1,000 or $2,000 a month until it depletes. So trusts are not just for the wealthy. Now, the second thing is that they're very expensive to set up. The truth is, unless you're trying to do something very complicated or very fancy, very involved, it really shouldn't cost a lot of money. I mean, some people think, well, I'm going to have to spend $5,000 or $10,000 just to set up a trust. No. A lot of attorneys, I think, will do it for much less than that. It pays to shop around. It pays to interview and talk to different attorneys. Pick one you're comfortable with. Pick one that you think is going to be fair with you. Get a pretty good idea up front of what it's going to cost you. And again, it won't cost a lot, and you can feel confident that you've arranged your estate to get the money to your family in the way you want to make sure that your goals are met with your family. So this is a real straightforward way of using a trust, and it's not just for the wealthy, and it doesn't have to be real expensive to set up. If you'd like to submit your question for me to answer on this program, send your question to questions@PlanStrongerTV.com. One more thing before you go. You need a little more understanding about the trust. There are some things to think about. Let me leave you with 2 quick stories about people I've seen firsthand use a trust very effectively for their particular situation. First is a gentleman I worked for a number of years before he passed away. I'm pleased to tell you that we took the time to set up an estate plan for him, working with an attorney, to where he had all his ducks in a row, including a trust. And when he died, his total estate was about $2 million. Now, according to his trust, money was all pulled together, everything was sold, put into one stack or one big pie, and then that money was dispersed out to his beneficiaries, primarily siblings. After that, the rest of the money in the trust was held and is still in the trust today for other beneficiaries. And those other beneficiaries are charities that he wanted to give money to. So my job as his trustee is that I'm now giving that money out to these beneficiaries in his name and making sure what he wanted to accomplish is being done. Now, second quick story for you. Husband and wife, 1 child with a history of chemical dependence. They have about $500,000. They're worried that if they just leave all this money to her in one lump sum, if they both die, that it will do more damage than good. In fact, their exact words were, it would kill her. So the way the trust is established, I'm set up as the successor trustee. If they pass, nothing changes until both of them have passed. They can still revoke or change the trust, but they pass, The money's all gathered up, and then she is going to be given an allowance. Money will be dispersed out each month to her, and if something happens where she needs to go into a rehabilitation center or something like that, money stops going to her and goes to the rehab. So just 2 quick stories on how you can really effectively use trust. Now, I hope you've enjoyed the program. Be sure to tune in next time, and for more information, go to PlanStrongerTV.com.